Good afternoon, everyone. Ian Maddox, Hitchcock Maddox Financial Partners, and today we are concluding our series on estate planning basics. The first week we talked about wills, living wills, healthcare directives, powers of attorney. Last week we talked about trusts, and today I want to talk about a subject that applies to a lot of folks, which is making sure that your beneficiary statements are up to snuff, and then the tax treatment of certain types of accounts when you pass. So first of all, there are some very simple and efficient tools to transferring assets from one generation to the next or from one generation to an entity. And on a lot of accounts, if they're qualified accounts, things like 401ks, IRAs, you have what's called, or insurance policies for that matter, you have what's called a beneficiary statement. You, the owner of that asset or that policy, can direct where the proceeds go, and it's a very smooth and efficient way to do it. You can name a spouse, you really can name a lot of things. You could name children, grandchildren, an entity like a church or charity. And what happens there, the power of it is that you skip probate. We talked about probate in our last series, actually the first video series, and probate is just really a legal proceeding where a judge has to review everything. And there's some things you can skip probate, in some instances you cannot. But with beneficiary statements on qualified accounts like IRAs and 401ks, or what's called joint tenancy, all right, you can have transfer on death, or excuse me, on a taxable account or joint tenancy, anything that's not an IRA or a 401k, taxable money, those types of accounts, you can add transfer on death instructions, TOD. You can do that at your bank, you can do that on a brokerage account, and it functions the same way. Essentially, it says to those that remain after your passing, these assets legally should pass directly, skipping probate. I've already determined that. So it's kind of a poor man's estate planning tool. The key, though, is to make sure, and many folks, unfortunately, have gotten caught in this, you want to make sure that your will and your beneficiary or transfer on death instructions match up. What often will happen is that, you can imagine this, we have a society where sometimes families are blended. We had a previous spouse, we've divorced, we've remarried, and it's easy to forget where all these policies sit. And you could have a will that you've created that says X and beneficiary or TOD instructions that say Y. The reality is that the beneficiary instructions and the TOD instructions trump the will. So you could have a child or other family member coming and saying, wait a minute, the will says this is what they wanted, and it could actually post-date. In other words, this will could have been created 6 months ago, and these beneficiary TOD instructions were placed on an account 10 years ago. And the reality is the law is going to say it doesn't matter. Those TOD instructions, those beneficiary statements trump what's in the will. So it's important to coordinate those things with our clients. We do a beneficiary review on a fairly regular basis just to make sure that nothing has changed. We're not with people all the time, and so circumstances and desires of people change over time. Now, the taxation of asset transfer. Let me talk about that for a second. So we've mentioned just a second ago IRA versus brokerage or taxable money. One is qualified. In other words, it hasn't been taxed yet. When you take it out, it is. The taxable account is taxed along the way. There's two different things that happen when you pass, and there's a lot of scenarios. Actually, I won't get into all of them. But with a qualified account, that asset can go right over to a spouse, no problem. That's easy to do. If it is a non-spouse, there used to be something called a stretch IRA, where you could take assets out of an IRA or a 401k, a qualified account, 403b, and you could set up a distribution for a younger generation that would go for the extent of the rest of their lives, just based on actuarial tables, the same type of math that insurance companies use, okay? Federal government does the same type of math. The Secure Act, I think I did a video on this 6 months ago, but the Secure Act changed that. Unfortunately, now the furthest you can extend that distribution period is 10 years. So instead of a lifetime, it's condensed down. There are some exceptions to that. I'm not going to cover them all today. On the taxable side, all right, this can be kind of a powerful tool. If you have brokerage money, even other assets like your primary residence, you get what's called a stepped up cost basis. So in a taxable account, you have money you put in. That money went in after you paid tax on it, but then it has the freedom to grow. Of course, it could go down too, depending on market conditions, but let's assume over time that it goes up in value. You put money in, that's your basis, your new value is up here, and this is how you create something called capital gains, all right? People are very familiar with that. If you have a brokerage account, you understand what capital gains are. The government says, you made money, we make money. It is what it is, whether you like it or not. If you pass with an account like that, an asset like that, and the next generation, though, can get that at a stepped-up cost basis, which means we go from your basis up to the level of the account value at the time of your passing, that becomes their basis. And so there isn't a taxable event there. So having some efficiencies, I guess, and looking at these types of accounts is important in your financial plan. Something you should review and consider when you're talking about estate planning is what type of assets do I have? How do they transfer to my heirs or wherever I want to direct those funds? So if we can ever be of help, give us a shout. Ian Maddox, HMFP. Till next time.